We're live.
There we go. This is the July 20th, 2023 in the matter of case file Z0064-23-SS, an appeal of the planning director's decision denying the application for Furwood Industrial Subdivision. My name is Joe Turner. I am the county's hearings officer. My role as the hearings officer is to conduct public hearings, excuse me, make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of County Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings examiner, or excuse me, hearings officer, wrong state, I am to provide an unbiased decision maker, and I believe I am unbiased with regard to the application before me today. I have not had any pre-hearing contact with any of the participants regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. I forgot to say I am also not a county employee. I am licensed as an attorney and trained as a planner, and I serve under contract to the Board of Commissioners. So that gives me a somewhat independent review of the application before me today. But regardless, you have the right to challenge my impartiality, to argue that I'm biased in one way or another. And you can do that when it's your opportunity to testify. Procedure will follow. Staff will first summarize the online hearing process, so everyone understands how you can participate in this online hearing. Then staff will summarize their staff report, copies of which are available on, or I guess in this case, it's the planning director's decision, and copies of which are available on the county's website. Then the applicant and this / appellant will have the opportunity to present their appeal, respond to the director's decision. If anybody else wants to say anything about this application in support, in opposition, or with questions or concerns, they may do so. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone an opportunity to respond to the testimony that was offered. If that response includes any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within 2 weeks after the close of the public record. I'll send that decision to the county. The county will send it to parties of record. So anybody who's testified orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. Anyone with an interest in this application may offer relevant oral or written testimony. The testimony should be relevant to the applicable approval criteria, which are set out in the staff report. And it's important that it's important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that the applicant have an opportunity to submit a final written argument without any new evidence. I have to hold the record open for 1 week after the close of the record to everyone else for that purpose. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open for any other purpose or to continue the hearing, you must make that request before the close of the hearing today. Also, my decisions must comply with state law that requires that I issue a final written decision within 150 days from the date the application was filed. So there's some limit to how long I can hold the record open or continue the hearing. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And although most people's names appear on my screen, sometimes when you start testifying, it shortens it up, cuts off sections of it. So I want to make sure I get the spelling right. And that concludes my introduction. I'll ask Ms. Dance to summarize the online process and also her staff report. You're muted, Ms. Dance.
Hi, everybody. I'm Liz Dance, Clackamas County Planning and Zoning. Today's meeting is going to be a public hearing. It will be conducted virtually using the Zoom platform. Panelists for today's hearings, which include the hearings officer, county staff, and the applicant appellant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. County will make every effort to post recordings on the county's website later today. There's a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar at the top or bottom, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see participants' cameras. Oh no, I scrolled down. Hold on a minute. You will see participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of the hearing and you wish to submit additional written testimony, email written testimony to myself, ldance@clackamas.us, or mail it to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, including the case file number Z0064-23 SS. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by email to the staff or contact for the applicant, or by entering it in the Zoom chat function during the hearing today. Okay, I'm going to do screen share. I have all my windows open, so can everybody see the Zoom meeting?
Yes.
Okay. So we're here to discuss the appeal. It's July 20th, 2023 of case file number Z0064-23 SS subdivision. The applicant and appellant are Ian Walsh and Wendy Kellington. Myself and Jennifer Hughes, the planning director, will be presenting staff findings. This is a property for a proposed additional three lot subdivision, kind of a replat of an existing developed industrial area. This property was established through a series of land use actions starting in 2002 with a rezone that was then, with a comp plan amendment, rezoned to rural industrial, and between 2002 and today has gone through several land use actions, including subdivisions, design review, to get to where it is today. The application that was submitted is for the replat of lots 3, 4, and 5 of the established subdivision, creating an additional 3 lots in the Firwood Industrial Park, making it a 9-lot subdivision Those 3 lots as created would be dividing and then sharing the established septic systems instead of establishing new ones. The application was denied because it would result in creating 3 new sewer systems, which is impermissible under OAR 660-011-0060 and Table 604-1 of the Zoning and Development Ordinance. The application otherwise complies with all other standards as proposed or can comply with conditions of approval. Staff has provided recommended conditions of approval, Exhibit 12, if the hearings officer finds that the application can be approved. This is a rural land use review, and as mentioned by the hearings officer earlier, it's subject to the 150-day review clock. The 150-day for this application is August 29th, 2023. And now I'll pass it over to Jennifer Hughes, Planning Director.
Good morning. As Elizabeth mentioned, we are really limited to just, at least in staff's view, one issue that is in question, and that led to the denial of this application, and that is related to the question of whether new sewer systems will be created if this plat is approved. And I just want to start, I guess, by being direct in saying that when staff denies something, it's really nice if we can identify kind of a public policy objective that leads to that denial. And in this particular case, I would say that the policy objective is muddled at best. And so I'll just concede that right up front. We struggled a bit in getting here, tried to analyze case law, consult with county counsel, read the OAR closely, read our code closely, to determine if there was a way to find for approval in this case. And we simply just ended up in a place of determining that no, we don't have the ability to do that. And in terms of whether there is a policy objective, I think the state would view it as preventing urban level or more intense development in rural areas. I'm not sure that really in this case you can argue that would be the result, but I think that was the policy goal when they drafted the rules the way that they did. There is no dispute that the 3 existing septic systems, or what are actually called under DEQ rules, on-site wastewater treatment systems, are lawfully established, or that the industrial development that they serve is lawfully established. Staff concedes that as being the case. ZDO section 604. Oh, Liz, can you? Yeah, just stay on slide 5 for now. Thank you. ZDO section 604 regulates the rural industrial zone, which applies to the subject property. Table 604-1 identifies uses permitted in the rural industrial zone. That table identifies 2 circumstances where a sewer system, and we'll talk a little bit more about what a sewer system is permitted, and neither of those circumstances applies in this case. I do think that note 4 in that table to one of the listed sewer system uses is instructive. I mean, I think it is drafted in a way that it is a kind of a check or a narrowing on the specific use that's listed in the table, in terms of saying you can potentially have sewer system components outside an urban growth boundary to serve land inside an urban growth boundary. And then the note says, but you can't have sewer system components that serve rural areas. So there's a tie there. And in this case, we're not arguing that they're proposing to serve land inside the UGB, but I do think the note is instructive in terms of clarifying that sewer system components generally are prohibited outside urban growth boundaries in most cases. The table, when we have a table of use, it establishes what's allowed, and things that are not listed are therefore prohibited. And I think that in this case, because we have stated specifically that there are 2 types of sewer systems that are permitted out in a rural industrial zone, that other sewer systems are not permitted. The ZDO, I think on its own is sufficient, but it's important to understand that there's context provided by the county's comprehensive plan and by the administrative rules that implement statewide planning goal 11. It is clear that our provisions in ZDO 604 are intended to implement our plan policies that also define the narrow circumstances where sewer systems are permitted outside urban areas, and that those plan policies are consistent with Goal 11 and are intended to be implementing those OARs, which are found at OAR 660-011-0060. We've included a couple of LUBA decisions in the record, and probably most instructive is the Lynn County case that I'll talk about a little bit more in a moment. Liz, will you go ahead and advance to the next slide for me? Thank you. So as I indicated, there's really just one question. Would the land division result in a new sewer system? So the first question is, well, what is a sewer system? And it is quite broad. The definition of sewer system is quite broad. Initially, when I read it in the rule, I thought, well, really, surely they must mean what we would sort of traditionally think of as a sewer system with all of the components that implies kind of a more urban level of development. But in fact, the definition is very broad. And I think that the Lynn County LUBA decision that's in the record makes it clear, as did a previous decision out of Coos County, makes it clear that in fact, on-site wastewater treatment systems can be sewer systems under the administrative rule. I should also note that the zoning and development ordinance does not include a definition of sewer system. So we are relying on the definition that is in Goal 11, which is intended to be implemented through our comp plan policies and the zoning code. And so really what makes something a sewer system? And that really is the question. Is a new sewer system created by dividing the land such that an existing sewer system serves more than one lot? Because in addition to sort of the physical components of a sewer system, the definition in the OAR keys in on this question of whether that system, whatever its physical nature is, serves more than one lot. The appellant is arguing that nothing is created by drawing a lot line on a map. And yet I would argue that in fact, new lots themselves are created by drawing lines on maps. I don't think that created necessarily means that something physical is happening. The Lynn County case that I've been referring to is essentially the reverse of this one. There was a situation where a development was being proposed. There were two existing lots. The proposal was to serve development on both of those lots with a single on-site wastewater treatment system. And LUBA found that in fact, they needed to consolidate those two lots before they would be allowed to build that single system that would then be shared by all of the development on the site. And so essentially the same exact system would be lawful if it served only one lot and not lawful under Goal 11 if it served two. So we have here the reverse, where the system is existing, there is not more than one lot being served by that system, and this land division will result in more than one lot being served by each one of those systems. And so if there were a way to distinguish this from the Lynn County case, I think that would be it. The hearings officer would need to find that the order in which these things happen matters in terms of whether something is or is not a new sewer system. In the end, staff was really forced to conclude that under the definition of sewer system, platting will create a new sewer system. And that's the reason that we denied the application. And then I just kind of want to add a little PS, I guess. I think that maybe there's some correspondence, if I remember correctly, in one of the exhibits about this, but there was some discussion between staff and county council, and I think ultimately the applicant, about what happens if we do approve this, because we're arguing that it's not a new sewer system. Then is it able, at some point in the future, are those systems able to be modified? Can it be, because the rule also talks about extension of a sewer system, and there's sort of this question about additional development, which doesn't really seem to be physically possible probably on these lots, but in this same circumstance in the future, if we were to approve it where there's additional development potential, are they able to build new buildings, change uses, add new, piping or something, or would that then effectively result in an extension? And so that's just, I'm kind of just throwing that out there as a PS, that it's something we need to think about if the hearings officer were to find that this could be approved. And with that, that concludes the staff's presentation.
Thank you, Ms. Hughes. Ms. Kellington, excuse me. And could There we go. I was going to ask you to stop sharing the screen. Ms. Kellington, are you representing the appellant? You are the appellant?
Yes, thank you. Wendy Killington representing the appellant. So I think, Dan, you were going to kind of do a little bit of an overview explaining kind of where we've been, but I can do that if you'd rather. Where we are, what's proposed, how we got here.
Well, I think Liz actually summarized the history of the land use decisions that got us to where we're at. And
Can
what
I
I
get your
heard-
name, sir?
I'm sorry, Dan
That's okay.
Simmons, and my address is 12805 Southeast Foster Road, Portland, and the last name is Symons.
Thank you.
And so
you're- Are you the applicant engineer or?
yes,
Uh,
civil
okay.
engineer.
Thanks. Go ahead.
So there's, as Liz mentioned, there was several land use decisions and design reviews that got us to where we're at. And I think that the main takeaway on that is that the lots 2, 3, 4, and 5, they're intended to be divided with this application are pretty much built out at capacity. There's no room to expand anything on with those lots. And I believe Jennifer kind of acknowledged that as well in her summary. And so I don't have a whole lot to add beyond that.
Perfect. So I'm going to share a screen. My name is Wendy Killington. I'm an attorney and I'm representing the applicant. So can you see my screen?
Yep.
Okay, it's hard for me to know. So
Yeah.
when I put it into presentation mode, I've got 3 screens and it takes them all up and it just, I can't stand it. And so I'm going to go ahead and do my little talk with you using this particular view, if that's okay.
It works for me.
Okay.
When you submit it, I mean, can you submit this into the record after the hearing as well? Just so in case there's something I miss, I can review it again.
Absolutely. I will
Thanks.
do that. Hopefully it will transmit. It may be too big. I may have to throw it in a Dropbox, but I think you can grab Dropbox transmittals, right?
I
I think
So,
I've done that
yes.
with you before. Yeah.
Well, you
Okay.
need to send it to the county as well, but if you could give us both the link, I think that would be okay.
Okay, perfect.
The county will make an exhibit number, but
All right. So I agree that I think Jennifer did a good job teeing this up, but nonetheless, I'm gonna tee it up again because it keeps me on task. So what we're talking about here is a 6-lot minor subdivision, which is a replat of 3 existing platted lots in an industrial park on 21 acres in the county's acknowledged rural industrial zone. To kind of see where the property is, you can, this giant red arrow kind of shows you where it is with relationship to other land uses around it, including the city of Sandy. This is a overall site plan that's designed to kind of help you to understand what's proposed on the site and what exists now and kind of what's new. And what you can see is the parent lots down here. There's parent lot 3, parent lot 4, parent lot 5. Those are the 3 lots that are being divided, and they're being divided into lot 7, 8. Hopefully you see my cursor wiggling around. I think you can.
Yeah.
Lot 9, lot 12, lot 10, and lot 11. So the only thing that is new going on here is this green line, because all of these other lot lines exist. The green is the only thing that is new. The property has a fairly well-established history. I asked staff and help to add to the record to make sure that all of the various land use approvals are in the record, as well as the septic system approvals that have been granted for each of the, to serve each of the structures, which are not changing here at all, just so that you have that in the record. And if you need to refer back to what approval gave what authorization, they're all here. And it also tells you, you know, what lots have how many buildings. And I think if I were in your shoes, I might like to refer back to this slide as I was writing a decision. That's the only reason it's sitting there.
And can we go back to that one real quick then?
Yes, we can.
The 2017, the first one,
Yep,
6 lot, was that completed? Was that
Yes.
finalized?
yes,
And then there was a partition
yes,
of one of those lots?
yes.
Okay,
And then almost immediately, there was a 6-lot subdivision, and Dan Simmons, a consulting engineer, is the person who sort of guided the applicant through those processes, and we'll know more about them, but yeah, so then there's the 6-lot subdivision that was approved on the subject property. That one was actually approved in 2019, even though it's got an 18 number on it.
right. Did that one subdivide a portion of the prior partition and subdivision?
Yes,
One of those lots?
yes,
Okay.
Yeah.
That's what I understood. Just wanted to make sure I was correct. Thank you.
yeah, you're welcome. And then at the end of it all, we end up with 20 industrial buildings that have received county design review approval that have been constructed on lots 3, 4, and 5. And then we have the phase 1 modification to add 9,000 square foot building. And then we have phases 2 and 3. So we end up with, you know, these 20, total of 20 structures, if that makes any sense.
Mhm.
And we have an existing septic system that serves 7 buildings. We've got another one that serves 6, another one that serves 7. Those are all approved, and there's no proposal to change any of them. So really, it's really important to start out this by really reinforcing that there's no new development that's proposed. And the applicant is bound by what it is that they have submitted and what will be approved. That's clear from these LUBA cases I cite that I'm sure you're aware of. We're not proposing any new structure or any new septic system. And there's no way for us to sneak something like that in anyway, because that's not what we've proposed and that's not what we've approved, that we anticipate would be approved. There is no room, as Jennifer acknowledged, on existing lot 3, 4, or 5, or the new proposed lot 7 to 12 to construct any more buildings between our drain fields, driveways, paving, and there's a required wooded buffer that's meets a landscape requirement in the 2017 original approval that exists. So it's impossible for any new structures that would require a new septic to even be established on the property. So the existing septic systems will continue to serve the existing buildings they currently serve. There's no request to serve any additional buildings. There's no possibility that the existing systems could be expanded to serve more buildings. And even if somehow they've figured out a way to do something like that, any additional connections would require county approval. So all we're doing here is just drawing 3 artificial lines across the property through the mechanism of subdivision. Now, the staff's decision denies the proposal based on this single issue that the 3 existing septic systems that now serve all the buildings that they now serve would still serve those buildings, but those buildings will now be on different lots. And so the septic system becomes a septic system as defined in the Goal 11 rule. And then staff concluded that pretty unremarkable fact meant that the proposal results in the creation of a new sewer system, and so is prohibited by the Goal 11 administrative rule. And it's that leap that is the place where we have a respectful disagreement with staff in this case. Staff also cited a comprehensive plan policy that basically says, comply with goal 11. That doesn't apply here for reasons that we'll talk about. And even if it did, there's no goal 11 problem. And ZDO table 6041 as bases for denial. And staff determined everything else could be or was met. So what's this appeal about? So the applicant's position is that the application should be approved, that staff misreads the goal 11 rule. It doesn't prohibit the proposed land division. It doesn't even apply to this application. And the plan policy and ZDO provisions cited in the staff decision simply don't prohibit the proposed land division. So let's start with the goal 11 rule. So the goal 11 rule has two relevant parts. It has a definitional part, it has a regulatory requirement part. Its relevant definitional parts are reproduced on this slide, and it's in 660 subsection 1F. Says a sewer system means a system that serves more than one lot or parcel. What we've got here is a sewer system that serves more than one lot or parcel. The second definition in 1A says the establishment of a sewer system means the creation of a new sewer system. The relevant regulatory requirements are expressed in the administrative rule in 660.11.60 subsection 2, not 1, 1 is definitions, which provides what it is a government isn't supposed to do. And government is not supposed to allow the establishment of a new sewer system outside urban growth boundaries or unincorporated community boundaries. And we know what there, and I think you're aware of this, that definitions are not prohibitions. And what the staff decision does, it impermissibly conflates the definition of a sewer system with the regulatory requirement not to allow a particular type of sewer system, and that is the establishment of a new sewer system. There's no rule that says you can't have an existing sewer system. It's only the establishment of a new one that's the problem. Definitions aren't prohibitions, and I meant to hunt for a LUBA case that says that, but I'm pretty sure there's one or two that do, and maybe even a court of appeals case. But I think that it's a fairly well established rule that the regulatory requirements are expressed as regulatory requirements, and definitions are simply that, nothing more. And so the drawing of lot lines doesn't create any new septic system, and it's not the establishment of one either. The only relevant regulatory prohibition simply doesn't apply, because here there's no establishment of a new sewer system, and that really can't be reasonably disputed. Let's see, lose track of where I am. The part here that I want to bring to your attention is that the rule doesn't prohibit land divisions. It prohibits the creation of a new sewer system. And again, that's not what's going on here. And as we get into interpretive maxims, in addition to state v. Gaines with regard to what does a plain text of the standard say? We also know that the regulatory interpretive maxims say that you can't omit words in a statute that have been inserted. And here, in order to get to staff's interpretation, you have to ignore the words that the LCDC legislature inserted regarding creation and new. And we know that that's improper with regard to interpreting laws. So there is some helpful case law out there, and the Lynn County case that is cited by staff is really not very helpful and doesn't really seem to apply, because there, in that case, that was the establishment of a completely new system. I mean, the staff said, we'd like to know if there's a way to distinguish it. I mean, that's the sine qua non of the regulatory requirement, is the establishment of a new system. And there, that was what was at issue, and that was determined to have been prohibited. But perhaps more helpful is DLCD versus Lincoln County, a Court of Appeals case that interprets the term establishment and extension in the context of water systems, that has kind of a similar regulatory world universe as the one that you see in the administrative rule that's right before it for sewer systems. And in that case, the court held, and there's a quote here, when the terms establishment and extension are considered together, the likely or intended parallel was the creation of a new system in an area and the expansion of an existing one into a previously unserved area, rather than the existence of an old system and its connection to serviceable locations in its present area. And that the phrase establishment or extension contemplates the new or expanded presence of water systems in areas where none was present before. And of course, here, that's not what we have going on. Here we have a system that has been specifically approved by the county, that exists, that isn't changing one iota. Goal 11 itself is also helpful to demonstrate as useful context under the gains analysis that the proposed land division would not be prohibited. Goal 11 differentiates between the presence, establishment, and extension of sewer systems, saying local governments are not supposed to rely upon the presence, establishment, or extension of a sewer system to allow, residential development outside UGBs at a density higher than authorized, blah, blah, blah. While the proposal may result in the presence of a sewer system, it cannot be the establishment of a new sewer system prohibited by the Goal 11 rule. And note, there's no issue of relying on the existing septic system to authorize density beyond, residential density beyond what's allowed in the ZDO. And the point we want to make here is that the use of these different terms in Goal 11 itself means that LCDC knew how to differentiate between sewer systems that are already present and those that will be established. And they chose not to provide any regulatory requirements for existing ones, only new ones that are to be established. Another interpretive part of the envelope might be the Fulton versus Jackson County LUBA case. It might be helpful to inform the Goal 11 rule's purpose. In that case, LUBA explained the purpose for Goal 11, and kind of like what Jennifer said, it's concerned with the presence or availability of a sewer or water system facilitating increased residential development, but probably increased development or density on rural land, presumably because that could lead to rural land being put to urban use in contravention of Goal 14. But here, of course, again, the presence of the existing sewer systems are not going to facilitate any increased residential or any other density on rural land or lead to any rural land being put to any urban use. There's no request for any new connection or structure or anything new other than artificial lines being drawn on a map. And as we've said, and Jennifer has said, there's no room for any new structure that would even need septic on these lots. So the Goal 11 rule simply cannot be properly read to prohibit the proposed land division. The existing sewer systems are all approved by the county. Their connection to all of the structures has all been approved by the county. All those approvals are in the record. The existing septic systems will continue to do what they're paid to do. They're not changing one bit under the proposal. So what are the local standards, actually any standards that can be applied to this rather homely application for a minor subdivision? So we know that only the standards that are codified in the county's code as being applicable to the subdivision replat can be applied. That's in a state statute, as you well know. And the standards applicable to minor subdivisions are specified in ZDO 1105, and 1105-01A requires the proposed subdivision or replat to comply with the applicable provisions of this section of the ordinance and section 1000 development standards. Well, this ordinance refers to the ZDO and not the comprehensive plan. So accordingly, what we're talking about here as the relevant standards that apply is ZDO 604, the RI zone, and ZDO 1000. Neither of those are Goal 11, and neither of those are the county's comprehensive plan. Now, there's a suggestion in the decision, and I have a little hard time understanding it, but there's a suggestion that the RI zone actually prohibits the proposed subdivision. But if the RI zone prohibited subdivisions, the county couldn't have approved the previous one, including the one in 2019 that's in the record. So I'm not, I think they may be, I'm not sure what they're saying, but if they're saying that the subdivision is prohibited, that simply isn't right. The relevant table, that table 60401, it doesn't prohibit any subdivision or replat that doesn't propose any development. And so far as I know, a land division isn't a use. The county code defines a use as purpose for which land or a building is arranged, designed, or intended, or may be occupied. I mean, a land division is simply drawing a line on the map. As a matter of fact, land divisions aren't included as allowed or not allowed on any ZDO use table. They're just not a use. So the fact that the ZDO doesn't say you can have a subdivision would not be a basis for denial. It just doesn't govern land divisions at all. And there's no discernible standard in table 604.1 that would discern any sort of standard about either the subdivision being prohibited, or that somehow drawing the subdivision lines as proposed more generally would lead to denial because of this issue that where the septic system will fall. So I think the county's position would be contrary to the 2 Court of Appeals cases I know you're aware of, Waveseer and Emsau, that says codified standards have to be reflected in the county's code. So staff has acknowledged that none of the prohibited scenarios in ZDO table 604 apply, but somehow nonetheless comes to the conclusion that the ZDO prohibits the proposal. And I don't really understand that. They spoke today a little bit about table 604.1 and footnote 4, but I don't understand how that could lead to denial here. So here's sort of a construct of what that table says, kind of sticking where the footnote is in the context of what the footnote says. And the regulatory thing that the footnote is getting to are sewer system components that serve lands inside an urban growth boundary, subject to a certain part of the Goal 11 rule. And then there's this footnote 4 that says components of a sewer system that serve land outside of urban growth boundaries or unincorporated communities are prohibited. But that clearly applies in the context of the regulatory statement that it relates to, which is not what is going on here. It relates to OER circumstances described in OER 660-11-63, which talks about components of a sewer system that serve lands inside an urban growth boundary may be placed on lands outside the boundary, provided certain conditions are met. But that's not what we're talking about. So I don't understand how footnote 4 can in any way inform a decision to deny the proposal. If anything, it just says that, you know, you can't do something that is not being proposed here. It would tend to support that the proposal is not prohibited. And I think staff said that because there's no corresponding part on the table that allows a land division like what's proposed here, that it must be prohibited. But as I'm sure you're aware, there are certain tables in the county ZDO that says use is not specifically allowed or prohibited, but this one doesn't say it. There's no such thing in the RI zone. And so I think for all sorts of reasons, the ones that I've described and ones that are probably obvious, and NEMZOW and WaveSeer and the, you know, codification rule, there's simply no basis in ZDO table 6041 to support a denial decision. In addition, the Goal 11 rule is not an applicable codified standard. There's a statute 197-175-2D that says after comprehensive plans and land use regulations are acknowledged, decisions are required to be based on the plan and regulations, and the goals seek to cease to apply directly, and that includes their administrative rules. There's no dispute that the county is acknowledged. The county cites comprehensive plan 7A9 as a basis for denial, and what that plan, comprehensive plan standard says is basically the same thing as the Goal 11 rules. It says the county is not going to allow the establishment of new sewer systems as defined in the Goal 11 rule outside of urban growth boundaries or unincorporated communities. But the applicable standards, as I mentioned earlier, are outlined in ZDO 1105-05A, which says that the applicable standards shall comply with the provisions of this ordinance, which is not the plan, that regulates a subject zoning district, which is, you know, the table and the parts of the RI zoning district we're talking about, and section 1000 development standards. So the county comprehensive plan policies, even if they did have some nugget that was useful regarding sewer systems, is not a codified standard that can be applied because the ZDO doesn't make it applicable. And a claim otherwise would require an improper amendment of ZDO 1105-05A by interpretation, which we know to be forbidden. So in conclusion, the hearings officer should find that, I think it would be helpful. The county said that they struggled with this. I think it would be helpful to say that the proposed land division doesn't create a new sewer system, and therefore isn't the establishment of a new sewer system prohibited by the Goal 11 rule, even though I don't think you get to that because it's not an applicable standard, but I know the county is interested in hearing from you on that topic. I think that you should rule that only codified ZDO standards that the ZDO makes applicable to the proposed land division can be applied to the proposal, citing WaveSeer, NEMZOW, and the statute. I think you should find that a minor subdivision replat, including this one, is not prohibited by anything in the underlying zoning district. I think that you should say that a proposed land division is not prohibited by the ZDO, the comprehensive plan, or the Goal 11 rule were they even to apply. And the proposal meets or can meet all applicable minor subdivision replat standards and should be approved. What else? I think the last thing I just want to mention is that I don't have a sense that the county staff are falling on their sword on their decision to deny. I think they would have wanted to approve had they, kind of understood how the rule works and how, the gains analysis and all these sort of maybe technical reading cases. They tried to read cases, how all these sort of technical legal things go together. And I don't really fault them for that. I think that it's a reasonably complicated situation for non-lawyers, but I do think that the legal standards here are pretty clear, that the definition is not the regulatory requirement. The regulatory requirement is that there shall not be the establishment of new septic systems outside of UGBs, and that's simply not what's going on here. And I would ask that you conclude in the manner in which we have suggested. And if you have questions, let me know. Otherwise, thanks to you and to staff for all of your time.
Thank you, Ms. Kellington. If there's anybody else who'd like to say anything about this application, you can raise your hand now. As staff noted, you can click on the raise your hand icon. Or if you're on the phone, *9. I don't think anybody is. And I'm pausing to give everyone a chance to find that button and click on it if they want to say anything. Are all the attendees county staff?
So I have a couple of
Yes,
clients.
Pardon?
So I have a couple, Wendy Killington, I have a couple of clients. So
Named Tracy, that's the only one they don't have a last name or know that they are county staff.
So Ian Walsh is a one of
Yeah,
the,
everybody else is participants and I can see them. So there are no raised hands. So there looks like nobody else wants to testify. Any response from the county?
Maybe just a couple quick comments, not much. I think in the presentation, Ms. Kellington mentioned that there's nothing that says you can't have an existing sewer system, and staff concurs. I think the rules are written to accommodate non-conforming uses, essentially sewer systems that were created before the rules were enacted. And I think that's kind of the crux of this, is that they don't have an existing sewer system under the definition. And in fact, if those three systems were sewer systems, we would not have been able to approve them in the time frame in which they were constructed. And then secondly, just the Lincoln County case. I know that Nate Boderman looked at that, the DLCD versus Lincoln County. I think it's important to note that that was in 1996 and that the goal 11 was amended in 1998 in direct response to that case because DLCD disagreed with the Court of Appeals decision. It did relate to water in that particular case, as Ms. Kellington mentioned. So I don't know how instructive, it may be instructive on certain points, but just in terms of the timing, the rule was amended in response to that. That is all I have.
Okay, thank you, Ms. Hughes. Ms. Kellington, anything further from the applicant?
yes. So let's see. So the regulatory distinctions, there's no prohibition about drawing lines on subdivision plats and not changing the way an existing septic system, serves existing structures. The only prohibition is on the establishment of a new sewer system, which simply is not the case here. That's not what's going on. And I've explained that, and I don't think I need to beat that horse. It's probably bloody already. And then your record includes the Goal 11 change, the goal 11 rule changes and that were made in response to the Lincoln County case. And none of them dealt with the situation that we have here. None of them were designed to kind of ratchet down on what counties could do. The standards, I don't know what exhibit number
I could
exactly
track it down.
you would
I know
have. but
I've looked at it.
Yeah, I think you'll see I think it's exhibit 6, page 30. You'll see exactly what the changes are. They have to do with health hazard extensions and what sewer districts can do to serve within their existing boundaries, even though, there may be some unserved lots, what the circumstances under which they can provide service to those. So there wasn't an amendment to sort of say, oh no, the determination in Lincoln County case about what constitutes a new or expanded system here was reversed because of great concern. No, it wasn't, and you'll see that. So again, there's no text that would support denial under the Goal 11 rule. The purpose of the Goal 11 rule does not support denial because we're not using a new sewer system to increase density. The context doesn't support denial either. The relevant context of Goal 11 itself makes clear that the LCDC legislature knows how to differentiate between existing and new systems, and they chose only to regulate new systems. You have to add words to the standard in order to get to denial, and that's contrary to 174-010. And so as a matter of proper statutory interpretation, the bases for denial are simply not supportable. They're wrong, and the staff denial should be overturned. So thank you.
Thank you, Ms. Kellington. Does the applicant want to waive their final argument?
Yep.
Okay. With that, I'll close the public portion I'll close the record and the hearing as well. I guess I'm closing the record. I gotta hold the hearing open until I finish talking. I'm going to take this under advisement. I understand Ms. Kellington just submitted some documents last night that I haven't had a chance to review yet, and I want to consider everybody's arguments that were raised at the hearing today. This is a unique case, as everybody knows, and it depends on the wording of everything that's in the record. So I'm going to review all that, and I will try and get my decision out within 2 weeks. I'll send it to the county. The county will send it to parties of record, which is the applicant/appellant in this case. And that concludes our hearing. With that, I will close the hearing and everybody have a good afternoon.
Thank you.
Thank you.